Good evening, everyone, and thank you very much for joining us for our talk and discussion this evening, Making SEND Mediation Work for Families. My name's Grania Mellon. I'm a barrister in the public law and education law teams at Garden Court, and we have a brilliant panel this evening to talk about all of the practicalities of SEND mediation. As many of you who are attending tonight will know through your work or through your personal experience, there is often an inequality of power which can have a huge impact on families in the SEND process. It itself can be an exhausting and protracting process, and that is even before it comes to the difficulties in getting legal aid. Before bringing a claim, a parent or a young person has to consider mediation, but is it a useful process? What can parties do to maximise the prospect of a successful outcome? We hope to have, as I've said, a frank discussion about the SEND mediation process with reflections both from the perspective of mediators and also from lawyers representing families. And I know many of you will have experiences and you are welcome to join in the conversation. Just some very quick housekeeping rules. Please remain on mute. Resources will be circulated after the webinar, and also just to let you know that the webinar is being recorded. That just means that the audio and video of the panelists will be being recorded and will be shared on our marketing channels, including social media. Please refer to any of the instructions in the chat if you're experiencing technical difficulties, and please join in the discussion. If you have any questions, you can do that in the Q&A function, and the chat function is also there for general comments, queries, or feedback. So I want to introduce you to our panel of speakers and tell you that the order that they're going to be speaking in. But before I do, and to get everybody engaged after what has probably been a long day in work, we wanted to start with a quick poll, which hopefully will work, given it does involve some degree of technical skill. So I think it should be launched and you can now see this poll. So I would like everyone, including our panelists, to vote for the various multiple choice questions, and then we'll come back with answers. So the first question is, what percentage of pupils in England have SEND? 3 choices for you to choose from. What percentage of pupils have an EHCP? In 2020, which was higher, SEND mediations or SEND tribunal decisions? That's a good one. Who pays for SEND mediation? Very important. If you could vote, and then we're going to reveal what you all said and crucially the answers very soon. But while those results are coming in, I just want to introduce you to our panel. And we're really lucky that we have such expertise with us this evening, starting first with Kate Aubrey-Johnson, who you should be able to see. Kate is a barrister in Garden Court and a founder of the Youth Justice Team. She's an experienced mediator with expertise in SEND mediations and works for the award-winning Kids SEND mediation service. She's the author of Making Mediation Work for You, which is a textbook many of you will be familiar with. We also have Margaret Doyle with us this evening. Margaret is a visiting research fellow at the University of Essex School of Law. She also is a mediator with SEND expertise, and she's also a researcher, so has a whole range of both academic and practical experience. She too is the co-author of a number of books, including Mediation in JR, a Practitioner's Handbook. And we also have Polly Sweeney joining us this evening. Polly is a partner in Rook Irwin Sweeney, and she has real expertise in a whole range of public law cases, including children and young people. I was very pleased to be reminded that in 2020, Polly received an award for her high-profile campaigning and litigation to maintain the educational rights of children with SEN, and that was one of the Law Society's Excellence Awards. So I'm sure you'll agree that there's a brilliant panel and a lot to discuss. We're going to hear firstly from Kate on the nuts and bolts of the SEND mediation process, the legal framework, and then Margaret on a research project on the participation of young people in mediation. Polly is then going to reflect on the mediation process from the perspective of a lawyer representing the child and the family, and then there's going to be a joint discussion between Margaret and Kate about the mediator's perspective on SEND mediations. So before I hand over to Kate, extremely exciting if there was a drum roll, I think that we can now see the votes in our poll. So of course, we do need the answers crucially, which I do have to check for. So the answer to question 1, 77% of you said it was 15.5%. That is correct. So well done to our learned audience. I feel like I'm presenting the Eurovision at this point. What percentage of pupils in England have an EHCP? Correct. The answer is 3.3% of pupils in England and Wales. That's 294,000 have an EHCP. And question 3, bear with me, what was higher in 2019, 2020? The answer is in fact SEND mediations and not SEND tribunal decisions, as most of you very understandably, and indeed I also thought. And then finally, who pays for SEND mediations? The answer is A, the local authority. So hopefully that was a good way to get us started. Thank you all very much for joining in. You're obviously already extremely knowledgeable, which of course we knew. So I'll hand over to Kate now for her introduction to the relevant legal framework.
Thank you. I'm going to close the poll. Hi, good afternoon, everyone. It's a real privilege to be part of this discussion. I am a barrister and a mediator, and I am a huge fan and supporter of the mediation process for resolving legal disputes. So I'm going to share my screen. And I have some slides. This is a whistle-stop tour through the SEND mediation framework. Given the expertise in the room or around the country, but in your rooms, I am going to move through these slides very quickly. So SEND mediation, as we're going to talk about it, is talking about the statutory provision of mediation. This relates to educational healthcare plans, and they were introduced, as I'm sure you all know, by the Children and Families Act in 2014. It's a staged process that starts with a request being made, by example, from a family or from a school for an educational health and care plan needs assessment. The local authority then has to decide, make a decision whether they're going to undertake that assessment. If they do decide to assess, then they have to make a decision whether to issue the EHCP. And if they do, then the parents have 15 days to consider that. And that may, at times, give rise to disagreements. This is just a summary of the definition of special educational needs, which can be useful because it is actually a very broad-ranging definition. And those of you who are familiar with EHCPs will know that they have a set of statutory requirement sections that have to be completed. And so, as I said, there are these staged processes, and that can give rise to a disagreement between the local authority's decision and the views of the parents or the young person. And those disagreements can be appealable to the SEND Tribunal. The decisions that are appealable as set out, and I'm referring to the Children's and Families Act when I put sections in brackets, the decision not to undertake a needs assessment is appealable. The decision not to issue an EHC plan as a result of the needs assessment is appealable. It's also possible to appeal decisions around if you disagree about the contents of the description of the child's special educational needs, the provision, the placement, and also following annual reviews, there may be a decision to reassess or to amend the EHC plan if that's not followed by the local authority. That could be appealed, and then decisions to cease to maintain the EHC plan. And all of this gives rise to a statutory entitlement to mediation. Now, I just wanted to make a note that you do not have to consider mediation if you're disputing the placement under section I. So this is a little overview, a snapshot of the way in which mediation is being used through the lens of one mediation service. So in 2019-2020, the Kids SEND Mediation Service provided mediation services to resolve disputes which were predominantly relating to either the contents of the EWHC plan or a refusal to assess. So that's right at the outset of a process. The local authority have refused to undertake that needs assessment. And then a smaller number relating to the refusal to issue that, so that they haven't issued an EWHC plan as a result of that needs assessment. And then there was a very small percentage relating to the decision to cease to maintain. And that's just a snapshot of one mediation service that provides mediation services for a number of local authorities, mostly in the London area, but also nationally. So who can appeal? The appeal can be taken in the case of children who are of compulsory school age by their parents, and then of young people over compulsory age, but under 25, that the appeal is taken by the young person. And that's an interesting situation, and maybe Margaret will touch upon the fact that the children under compulsory school age are relying on their parents to bring the appeal, and where young people lack mental capacity, the appeal can be brought on their behalf. So it was quite a radical shift, really, to say that there is a compulsion or there is a requirement to consider mediation if, having an appeal right arisen in the EWHC process, you want to go to the SEND Tribunal to pursue that appeal or to resolve that dispute. First, before you do that, you have to consider mediation, and that process is that you have to speak to a mediation advisor. And the mediation advisor will talk to you and give you advice about the mediation process. And at the end of what is called a SEND Mediation Information and Advice session, a MIAS, you decide you don't want to pursue mediation, then you get issued with a certificate. And if you decide you do want to consider mediation and have a mediation with the local authority, then that mediation process takes place. And when that is complete, the certificate is then issued. So you don't lose your right of appeal. And as I'll touch upon in a moment, for parents, this is a free service. It's paid for by the local authority. And we'll look at the impact of this and the changes to the entitlement to the support that comes under an EWHC plan on the use of mediation in a moment. So that's the requirement to consider mediation. It's worth just touching upon the fact that this relates to the education sections of the EWHC plan. You don't have either an entitlement or a mandated duty to consider mediation in relation to the health and social care aspects of the plan, but if they are also part of the discussion, if you've got an education component, you can discuss the health and social care elements. Obviously, that can become a problematic if they're intertwined. That can become a problematic issue. And there's currently a national trial looking at the powers of the SEND Tribunal to look at health and social care sections of the EWHC plan, because you wouldn't be able to pursue an appeal to the SEND Tribunal on health and social care alone. That trial is ongoing. The link at the end of the slides, because very interesting, the trial is being independently evaluated, and any decisions of the SEND Tribunal that relate to this temporary power are being published. So if you're interested in that, there'll be a link at the end of the slides. So what did this new framework, what duty does it place on the local authority? Well, they must provide information about mediation. That means it must be set out in their local offer. And sometimes that, or usually that will mean that they will engage a SEND specialist mediation provider to provide their mediation services. And the local authority must inform families and young people of their right to mediation. They must arrange and pay for the mediation. And perhaps what's potentially a controversial aspect of this is that they must send a representative to to mediation. And not only must they send a representative, that representative must have decision-making authority, what might be called more generally in mediation, authority to settle. The importance of that is it should really be quite a senior member of the local authority who has got the power to make the decisions or change the decision that's being challenged. And there was a question at the time about whether the compulsion for the local authority to attend was going to in some way undermine mediation, because one of the core components of mediation is that it's voluntary. And maybe we can explore that in the discussion in a moment. What are the duties on the mediator? Well, they must be independent of the local authority, and they must have knowledge of special educational needs legislation. And after this framework came in, there's now been an accreditation developed for SEND mediators. And as I said earlier, these services are usually provided under the umbrella of a SEND mediation service. Now, who attends the mediation? That has been a hot topic, and it was the subject of litigation in the case of Kumar and Hillingdon. In our experience, usually there is no objection to who attends. It's the people who are best able to provide information about the dispute under consideration, and are best able to support the family and support the local authority in making that decision. So obviously the parent or the young person, and in the case of the young person, it may be their alternative person if they're unable to attend, but also unable to conduct the mediation. Also the child, and Margaret's going to talk to us about the involvement of children in the mediation. And then a parent is entitled, or young person, to an advocate or supporter. And in the case of Kumar and Hillingdon, the dispute was that the London Borough of Hillingdon didn't believe a lawyer or objected to the lawyer attending. In our experience, it's really important to have the right people in the room. So often a friend who is able to support the parent, or SENDIAS advisors, other advocates, are extremely helpful in the mediation process. Also, quite often the school will attend. It might be a teacher, it might be who supports the child normally, or the SENCO or the head teacher. And there may be therapists, other support workers working with a child who understands their needs, who again can support the parent in providing the information needed to help the local authority make an informed decision. And in the case of the local authority, quite often it will be more than one person who has been involved in the case, and quite often it may be the caseworker who's got the direct involvement, as well as a more senior manager. And in the case of the structure of a local authority where there's a tribunals officer or manager, they may also attend. If it involves health or social care, it's important that the CCG also attends. The principles of mediation, as they are across all types of mediation, are that it's confidential, but it's really important that it's informal, as well as being a structured process. SEND mediation puts the child at the heart of the process, and they're at the focus of the mediation process. As I said before, the mediator must be independent, but also impartial. The discussion is confidential, but you work towards a solution-focused outcome, and that, if agreed to, is not confidential. It's important to ensure everybody's voice is heard, but it's a strong focus on the child. Usually it will be the mediator who writes a mediation agreement setting out actions, and this doesn't, even if you form that agreement, it doesn't affect your right to appeal. And I think what I'm very keen to emphasise is that, and both Margaret and I would like to emphasise, is that the decisions, the mediation agreement, may lead to a definitive decision to issue an EWHC or to undertake a needs assessment, but it may be an action plan, next steps, an agreement to provide further information, to arrange a further meeting, or to address communication issues or breakdowns in communication that have occurred. So it isn't always an agreement that resolves the dispute that brought the family to mediation. It may narrow the issues, it may resolve some immediate needs. So when we look at what are promoted as the benefits of mediation, It's got a very high settlement rate. This is the national settlement rate of 85%, according to the government statistics. In fact, I believe that the kids mediation service that both Margaret and I have worked for is a higher rate of maybe 87%, but that may not prevent the parent from still going to the tribunal because the underlying issue that brought them to mediation has not been resolved by that mediation agreement. Key benefits are, of course, it's free to the family, and that it is child-centred, but perhaps also very important, it can be quick. And waiting for that tribunal date and decision can take a very long time, and this can happen relatively quickly. And in a child's life and progression through the education system, that can be very important. It's non-adversarial, solution-focused, and it can provide an opportunity to build trust between the local authority and families. And it also is an opportunity for the local authority to reflect on the way they work with families. It would be incomplete for me just to talk about mediation, because within the SEND framework, there are a lot of disputes and issues that arise that fall out of this statutory mediation provision. That in the SEND framework is described as disagreement resolution, but in essence, it is mediation that's not part of this statutory framework. And it is available in a number of situations. And we were talking just before we started this seminar that actually, if you ask the local authority, they may well provide mediation outside the statutory duties that they have. You might want to also try mediation in judicial review or in cases involving disability discrimination. I've set out the legal framework here, the details of the trial as I mentioned it, and also some really helpful guides that provide greater detail about mediation and disagreement resolution. So thank you. I'm going to stop sharing. I probably have run over time, my apologies.
Thank you very much, Kate. You haven't run over time at all, and that was a really interesting and comprehensive summary of the relevant legal framework and the nuts and bolts. I think we're now going to hear from Margaret, who is going to, as I said, talk a little bit about the participation of children and young people in the mediation process, and in particular about research conducted, which I think is called A Place at the Table. So Margaret, over to you.
Thank you, Grania. And thank you, Kate. I just wanted to say, Kate, I really appreciate that you use the word impartial instead of neutral, because I can't stand it when people talk about mediators as neutral, because actually we're not neutral at all. And one of the things I wanted to show, I brought some props. One of the things I wanted to show was the old code of practice from 2001, which was this thick, and the new code of practice, which is this thick, which is like a monster of a thing, but it has all of the things that you're talking about, Kate, in terms of the legal framework. And when I talk to parents about it, I sort of explain that it's, you know, it's a monster of a thing, but it's so useful. And one of the things about doing everything online now is, of course, we don't have to lug it around physically and drag it on trains with us and that sort of thing. So let me just share my screen. Okay, can everybody see that? I can't see that well. Let me just move over. Right, okay, so I'm just going to talk briefly about a project that I carried out in connection with the UK Administrative Justice Institute at the law school at University of Essex that I'm linked with. It was a project also carried out in connection with Garden Court Chambers, which supported the project, and with KIDS, the SEND mediation provider that Kate's already mentioned. And it was what's called a knowledge exchange project. So it was really about bringing together people with perspectives on the involvement of young people in resolving disputes and disagreements about their special educational needs. So it involved probably several of people in the audience here today, lawyers and mediators and local authorities and schools and parents and parent care forums. Basically, it was looking at the issue of 16 to 25-year-olds as rights holders. As Kate mentioned, the the Children and Families Act in 2014 made it clear that at age 16, the right to appeal or to request mediation is for the young person to do that. They can obviously request a parent or someone else to take a case on their behalf, but they need to give their permission that that's happening. So that was a new thing, and I was interested both as a mediation practitioner and also in terms of the work on administrative justice that I was doing to really look at how that's working. Again, that applies only in England, and I wanted to focus primarily on mediation. So although I touched on the tribunal in the project, the focus on mediation was important because of the sort of distinct decision-making role that parties have in mediation. There is a final report. There's a project website at the end of these slides. I have the website address for that. So there's the final report there. There's a blog, including some guest blog posts that were made by participants in the project, and also a report on a roundtable project, a roundtable meeting that we had at Garden Court Chambers, in fact, before while the research was being carried on. And the key themes, the three, and the one I'm really going to talk about just briefly here is participation, but I will touch on the other two. But the first one's really key, and it's about this question of what do we mean by participation in SEND, and particularly in SEND mediation. And I'm talking about individual participation as opposed to participation at a more strategic level. There's quite a lot of work that's going on with disabled young people in terms of strategic participation and influencing commissioning of services and that sort of thing. But this was about individual young people. And I also looked at the question of mental capacity and how it's understood in SEND, because one of the issues about the right, being a rights holder at age 16 is unless you've been deemed to lack mental capacity, in which case, as Kate mentioned, a representative who could be your parent or another representative would take the case for you. And then the question of information and advice and what access young people had to information to help them take their own case. And again, the couple of reasons why mediation is of particular interest in this area, and one is that steep increase in the numbers of mediations that have been held. And I know in the poll, it was interesting that most people thought that there were more tribunal decisions. There's certainly been more tribunal appeals registered than SEND mediations, but in terms of actual mediations held, there are now more than decisions being issued by the SEND Tribunal, but it's a huge increase since 2014 and before the Act came in, when we had about 75 nationally, 75 SEND mediations. And all this is happening without much scrutiny at all of what's happening in mediation. And it's a real concern to me and some of my colleagues that we're having this exponential increase without really examining what's happening or looking at patterns in the outcomes of those. But as I said, the distinctiveness of parties' decision-making role in mediation makes it really different from the tribunal or a complaint to the local government ombudsman or judicial review, because in mediation, it is the parties themselves making the decision. So it's not a third party sort of hearing people's views and then making a decision for them. I think also the flexibility of the process allows for more creativity in facilitating participation by young people. And that's a benefit. It's not something I think mediators have done as much as they could with to bring young people into the process. It's been really interesting since in this past year, and we've all had to go online to see how that actually facilitates young people's involvement. And I think Kate and I probably both have. I know I certainly have had some cases where young people have been able to attend online in a way that they probably wouldn't have been if we'd been meeting in person. So we could say a bit more about that later. And I think the confidentiality of mediation, which is one of the fundamental principles of mediation generally, but I think in SEND it's really problematic. And I'd like to have a discussion about that, because although the discussion is confidential in mediation, the outcome, the agreements that Kate mentioned, those are not confidential. But even this cloak of sort of confidentiality around the discussion, it can be helpful. It can certainly be helpful in terms of moving people forward, but there are concerns about, I think, whether it's appropriate in a public law context to have that sort of confidentiality without a little bit more scrutiny. But really positive things about the opportunity for holistic outcomes, and Kate was referring to some of those. So it isn't just about the issue that brought you to the table, but about all these other surrounding issues that support this young person in terms of communicating with the school, the long-term relationship, issues of trust, and also what I think is interesting is building the resilience for dealing with conflict in young people. And I think mediation can help them do that by giving them a place at the table. Kate already mentioned the practice standards. So those came in 2018, and that's was intended to bring some reassurance, a level of confidence to families and young people and to local authorities that the mediator involved in that case does have the knowledge of the SEND legal framework and the code of practice. So here are those figures on the numbers of SEND mediations, and I think this is something that quite surprised me actually when the figures are collected by two different government departments, so they actually don't get published together. And I thought it was interesting to see the difference in them. Of course, appeals have gone up hugely, as mediations have, and I think Kate has referred to the element of compulsion. It's now compulsory for local authorities to mediate if the family or young person wants to. That certainly could be a contributing factor in the increase in mediations. Also, simply the fact that the code of practice now covers from birth to age 25, which is many more young people than were covered previously. So we don't really know the reasons for these increases, but again, I think for me, it's a bit of a rings alarm bells about, do we have an unsustainable sort of assembly line of disputes, and are we actually learning from these to try to prevent these from actually coming to mediation and tribunal if they don't need to be? And I think particular areas, Kate showed you the pie chart from kids that shows that refusal to assess cases are a big chunk of those coming to mediation, and in my view, I think we probably don't need as many of those coming to mediation because those can get resolved earlier. But again, we can say a bit more about the how that plays out in mediation. Some of the observations from doing this project, some of my observations is that there's a real disconnect between this policy ambition of participation of young people that comes out really strongly in the Children and Families Act, which is very much talks about decision-making rights, but a disconnect between that and what's actually happening on the ground, because young people are really not exercising these rights on SEND in the way that we might expect them to do. But there are lots of reasons for that. And one of the things that came out in the project is that participation is, for these young people in particular, is both a source of anxiety for them and their parents, but also a means of empowerment. And one of my colleagues mentioned at the roundtable meeting that it's a bit like your child learning to drive. You know that it's going to be hugely liberating for them, but it just is terrifying, the thought that they might be out there behind the wheel of a car. One of the things that really concerned me is I had the impression that the legal concept of mental capacity, as in the definition under the Mental Capacity Act and the way that that mental capacity is assessed, is not well understood in SEND and is often used quite loosely in a way that's a real barrier to young people participating in a meaningful way. A lot of assumptions made about capacity and not a lot of clarity around when that's actually assessed in the way that it's intended to be. And generally some problems with insufficient data and also guidance. Young people have not, up to the point I was doing this project, had not been very involved in producing any guidance for the tribunal or for mediation. And I think that's something that needs to happen. Just want to check, am I okay on time? One of the things to point out is that traditionally in the past, mediators, and I think the tribunal have and still do for the most part take what's called a welfare approach to participation. And that's about, you probably heard expressions like the child's voice or expressing views. And it's about information being given to adults as the decision makers. And what I think the Children and Families Act does, and it's reflected in the Code of Practice, is to take a citizenship approach. And that's one where participation is about encouraging the actual involvement and decision making of that young person. And that I think is not really happening. But I think actually probably what we need is something that recognizes the value of both of those, because it's a real challenge to reconcile a rights-based approach with the very understandable need to ensure the well-being and support for these disabled young people. So it's trying to take a bit of both of those things, and I think we don't have it right at the moment. But also that participation takes many forms. So it can be sitting literally at the table with the others involved in the mediation. But certainly in my experience, I've had lots of interesting ways that young people have chosen to participate. And as I said, being online has been really interesting to see how that offers new opportunities for young people to participate. And it can be direct or indirect. And the key thing is really about young people deciding for themselves how they want that participation to be. And just there's a few reasons why this is so important. And these are often seldom heard voices, and the disability rights movement, the sort of the saying about the importance of doing with as opposed to doing for or doing to, really is important in this context. But also, as I mentioned earlier, there's a real need for young people to sort of practice decision making. This is something in the project when I was speaking to Douglas Silas about this issue, and he was really keen on this. That it's sort of helping to build resilience in young people if they're actually involved in supported decision making. And young people and disabled young people have as much a right to make bad decisions or make mistakes as everyone else does. So we only really learn through practicing. But also this potential for more sustainable outcomes, because if young people are actually having a say in the outcome, it's likely to be something that's going to be more sustainable for them. But there are some risks, and I think it's really important that we think about these too, because there's a perception among parents, and I completely understand where this comes from, that local authorities might prioritise a young person's views over their parents' as a way to affect decision making about things like continuing in education. I'm not sure how much local authorities are actually doing that, but I know that that's a perception and a fear that some parents have. And also there's a potential conflict between what parents want and what the young person wants. And the risk to bringing that to the surface is that it can jeopardize this relationship of trust that's so important there. And I think we need to just recognize that that's not something, we don't want to drive a wedge between parents and their young people. We need to support that relationship of trust while also helping the young person to be involved in supported decision making. It's also clear that if a young person in, say, a mediation context shows how competent they are at decision making, or they're very articulate, that they'll be considered to be less in need of support. So again, that's a genuine fear, or that their silence is taken as consent, and that's another thing that certainly I've experienced a young person attending. But their engagement is makes you wonder what their views actually are, but they either are not willing or not able to communicate that, or they don't want to. And there's also a risk of a sense of failure if there's no agreement, that young person might think, well, I've messed up here because we haven't reached agreement. Something also that's not on here, but I think is a very real risk, and I've certainly seen it happen, is what I call Exhibit A syndrome, where particularly a child more than a young person is brought into a mediation to kind of show the difficulties they have or the challenges they have, and it's really uncomfortable. And I think we need to just also think about that as mediators, how we can incorporate those sorts of scenarios and respond to them. But there are lots of ways that young people can participate, and I think it's about being creative and really thinking about the different opportunities that we have, and mediators could do more on that. I said I just touched briefly on mental capacity, but I probably have run out of time. But just to say really that I was quite concerned that there was a tendency to leapfrog straight to this notion of best interests and use this concept of capacity very loosely when it comes to young people with SEND, which really reflects that welfare approach of mediation. And certainly there was a parent at the roundtable meeting who discussed a situation with her young adult daughters who were deemed to lack capacity because of not having had any decision-making experience. And you can imagine being in that sort of circular way of reasoning must feel really impossible if you're the parent or the young person. And on information and advice, there is a duty on local authorities to provide advice and information to young people, and also access to advocates. But I found little evidence that that was happening. I mean, at the time, this was 2018, 2019, and I was looking through the local offers of different websites and speaking to a number of people involved, and it didn't seem to be happening in the way that I think the Children and Families Act had envisioned it happening. There's been a bit of work since then on producing more accessible information, and the link that Kate gave at the end of her presentation to the disagreement resolution fact sheets that are on the Mott MacDonald Pathfinder site. There is a new, well, fairly new leaflet designed for young people to explain the processes on that. So we can see a little bit of progress in terms of that last point about developing young people specific information. Just some things I think coming out of the project that we really need to look at, and part of it is a sort of culture change about how we view young people and how we think about supported decision making. Another point, which again is something Kate touched on in her presentation, is that the vast majority of pupils with SEND are supported through SEND support through schools and colleges, and at the moment there is a major gap in terms of any sort of independent oversight and means of resolution of disputes, because that part of the local government ombudsman's remit was taken away from it several years ago, and so it's not something that you can go to the ombudsman with. And mediation is appropriate, but there isn't any mechanism for it to be provided or funded except through a SEND mediation provider, but with possibly schools and colleges paying for it. So it's one of those things that falls outside this sort of statutory framework that Kate was talking about. So whirlwind tour of that project. Just to say, the report is available at that website and some other resources, and my contact details, and the report looks like that. And do have a look if you're interested. There's a lot more than I have been able to describe here. So thank you. I'll just stop share now.
Thank you very much, Margaret. I'm sure that others agree that that was a really interesting and thoughtful series of reflections on the mediation process, and in particular the participation of young people in it. Thank you very much. I'm sure there'll be some questions following on from that, which we'll come to at the end. But I think now we're going to hear from Polly, who represents families and children in education appeals and in the mediation process, for her reflections.
Thank you so much. It was really interesting to listen to all of Margaret's experiences through that project, and so much of it resonates with the work that I do, acting on behalf of parents and young people in tribunals and also in mediation. I thought that what I would do is share my top 10 tips for making the most out of mediation. I should say these are very much my personal experiences, and I really appreciate that there are a range of views in relation to mediation, but I hope that it will be helpful nonetheless. So I think, number one, the first thing that I always do with my clients when we have a decision and they are deciding whether to try mediation or go to tribunal is to say, what do you have to lose? Because as I think has already been said at the beginning, the reality of tribunal at the moment is that it could take 4 or 5 months to have a final hearing, sometimes much more than that. And throughout that time, the child or young person is often not receiving the right support. So there is a time imperative with so many of these cases. In contrast, my experience is mediation can be arranged very quickly in a week or so. And so even if there's only a small chance of resolving the matter, it's often worth a week's delay in issuing your tribunal just to try and see. Now, of course, though, and this is I suppose my second thought, is it's important to recognise that not all cases are suitable for mediation, and that's okay to say I'm not going to mediate. Sometimes it's really clear that the positions between two parties are just too entrenched, that you're not going to resolve that ultimate dispute. But I still think sometimes mediation can still be used, but you can use it for discrete issues. And this is particularly important given the length of time it takes to get to a final hearing. Some of the reasons ways I've used mediation is say, well, look, we're never going to agree on placement, or we're never going to agree on some key parts of Section F. But why don't we use mediation to see if we can agree the rest of Section B of a plan, or can we try and agree at some discrete issues where it looks like we might be closer together? And those bits can then be sorted, and that provision can be put in place for the child whilst you're then mediating or going to tribunal over the big issues. I've also used it to successfully to agree the interim position pending a tribunal appeal as well. And so particularly if there is there's a concern about what's going to happen in the meantime, seeing if you can reach an interim solution that's just going to keep everybody going to a tribunal. So absolutely, it isn't the right thing in all cases, but it's a good opportunity, I think, to find some common ground as you move into a tribunal, if nothing else. And then number 3, linked to that, I think, is knowing when to walk away in a mediation. As Kate's already touched on, this isn't a voluntary process for local authorities, and I think it's inevitable that sometimes representatives are going to attend without the intention to settle. And when they're being asked to come on without it being voluntary, that's just going to happen. And I can often tell within sort of 15 to 20 minutes of being there if we're in that situation. And I don't think there's any harm in recognising that and asking it for it to be brought to a conclusion. Everybody's time is precious. Parents, just as much as professionals, time is precious. And if you can get a sense that this just isn't going the way you thought, I think to not be worried about bringing it to a close. So number 4, for me, the biggest benefit of mediation is that it's crazily the only point in this whole process where the parent or the young person has got a legal right to request that representatives from education, health and social care are all in one room together. You don't even get that at tribunal, because the tribunal doesn't have the power to request the CCG has got to be there. So it is, in the whole process, the only opportunity. And often, particularly when you have complex disputes between who is responsible and there is overlapping provision and overlapping needs, given this whole process was set up to be able to look at a child or young person's needs in a holistic way, this is actually the only way to do that often. So that can be good for those cases. But as I think Kay has touched on, make sure that everybody that's attending does have the legal authority to make those decisions. And I think you can ask the mediator to make those inquiries and get those assurances beforehand, because there's nothing more frustrating, and I've been there, where you turn up and you think you're making progress, but halfway through the local authority officer says, oh, no, I have put this to panel, I can't agree to anything today. And you think, gosh, what's the point of being here? So I think make sure that you've clarified that beforehand so everyone's really clear. Number 5, preparation. For me, preparation is really, really important to get the most out of mediation. Often you only have half a day to do this. Sometimes we might be able to get a day, but often my experience is they're just listed for half a day. And you need to be really focused on what you want to achieve, and that it might not be possible to go through every point. And so I always work with my clients to kind of agree a list of priorities and in order with which you want to approach them as well, so that you're spending the most amount of time on things that are the most important. And then also in terms of preparation, making sure that you have all of your evidence ready. So for example, if it's a refusal to assess mediation, being really clear, what's the statutory test, what's the evidence to support that? Or if it's a B&F appeal, there's no harm in preparing a working document in advance and tracking in the specific wording. Because if mediation isn't successful, that's all work that can then be used for the tribunal appeal, so it's not wasted in any way. And then part of the preparation as well is thinking, as Margaret said, about how the child or young person can be supported to participate as well. So you're thinking about that well in advance, particularly so I've had young people who didn't want to be there, wanted their parents to represent them, but wanted to make a video beforehand that we could share. In a recent case, the young person joined the mediation midway through because it was a remote hearing, spoke to the mediator directly. Everyone else had their videos switched off and just spoke to the mediator. The mediator asked some questions of the young person, and then the young person left the mediation and left the parties to continue. So making sure you think about that in advance, because often for that to work well, it needs to be well planned. Then number 6 is, as we move out of COVID, we've been mediating using remote technology, and I wonder whether, I don't know yet, and it'd be interesting to hear from Kate and Margaret, there might start to be options provided. Do you want to have it remote, or do you want to have it face-to-face? And I have to say, I found remote tribunal hearings worked really well, but if I'm honest, I found that remote mediations work less well. And I think what often works best is when the mediator is able to shuffle between rooms. And I know you can do that in a breakout rooms, but I've just not felt it's worked quite the same way. And I also wonder if parties aren't as invested in the outcome, because it's so much easier just to switch on a Zoom link and join rather than actually going there in person. I don't know. So I think if I have a choice, and obviously it'll be down to the clients to decide, but I felt in the past face-to-face has worked better than remote. So then number 7, and this is about legal representation, and this, I guess there will be wildly different views about this. My view is that having legal representation at mediation is generally more helpful than it hinders. Of course, I guess people will say I would say that, but I've always thought that the best outcomes are achieved where you have a mediator who's got really good experience of SEN law, and both sides are legally represented, so they're getting good legal advice. And so it's not just about the family member being represented, but the local authority themselves having good legal advice about these issues. And it's in that forum that I more often than not, resolve the case. And it's those sorts of discussions that often don't happen until right outside of the court hearing when you're in a tribunal, that you can have at a much earlier stage. That said though, and this is my point 8, I think when we're talking about the role of legal representatives, trust is really, really important in terms of how we act as a lawyer in those mediations, because I know initially when SEND mediation first started, mediators were very worried at the idea that I would be attending that process, and local authorities as well, and the concern that by a lawyer being there, it would make the process become very adversarial. I hope that through my attendance, parties can see actually that me being there makes it more likely to lead to a resolution, particularly if I already have a relationship with the client. The idea that my client who has relied on my legal advice, perhaps for many months, is then going to go off on a mediation on their own and not want to defer to me for my views and advice on any kind of settlement. I think it's more likely to be a collaborative process if I'm there, because I can reassure my client this is fine, we can agree this, or we can agree things that perhaps we might not have thought about if we were going to tribunal. So I think though as a solicitor attending mediation, you do need to recognise your role is different to advocating in a tribunal, and it's much more about working with the mediator to try and find a solution. And so I make sure I often have a conversation with my clients beforehand to manage their expectations in terms of how I'm going to be as well. And so they might expect me as their solicitor to be quite, I don't know, perhaps adversarial, or perhaps to speak up on their behalf, and I have to have a conversation with them beforehand and say I'm not going to be doing that. I'll obviously not make sure anything goes wrong, but we do need to be really collaborative here. So thinking about managing clients' expectations is really important. So then number 9, 2 left, number 9 in terms of my top tips is making sure that parents and young people who are unrepresentative are mindful of not conceding cases in mediation prematurely. And so I've known cases where the child really obviously meets the criteria for statutory assessment of their needs. And during the mediation, the local authority has offered to the parents that they'll reconsider in 6 months' time after further evidence, further assessments. So parents have agreed to this, they've gone 6 months, then further assessments and evidence, and there's just another refusal decision. And actually, you know, that was a case which it should have just been either agreed to do a statutory assessment or the parent should have gone to tribunal. And I've also had cases where, you know, I've seen agreements that have been reached during mediation about amendments to a plan, and it's immediately obvious to me that the provision that's been agreed is just completely unenforceable because it's not been quantified or specified. And parents then come to me saying, oh, you know, this provision isn't being delivered, and I'll look at it and say, there's nothing there we can enforce. So I think there is an interesting question, and I think it would be good to hear from Kate and Margaret if we had time about the role of the mediator in drawing up these agreements, and, you know, where an outcome is so obviously unfair to an unrepresented parent or a young person, you know, what are the ethics around that? And because I have seen some decisions which I would really question whether they should have been reached. Fortunately, that is not, you know, that's not a regular occurrence, but something to think about. And then finally, just understanding the status of that mediation agreement and what to do if it's not complied with. I have been involved in a few cases where the mediation agreement has been breached. And I think it's important just to remember that there are a number of remedies available, so ranging from a complaint to, you know, potentially enforcement through the courts as well, dependent on the nature of the agreement that's been reached. What I would say is that if actions or follow-up steps are agreed during a mediation agreement, I always try to keep those dates falling within 1 month, so that if things don't happen and the actions aren't complied with, you're still in time to lodge an appeal and you're not left without any remedy at all. And so, you know, of course, you still have a right to go to tribunal, whatever happens at mediation, but that's got to be done within that fixed period. So that was my top 10 tips for mediation, which I hope will be helpful, and perhaps we can discuss a few of them if there's time afterwards. Thanks.
Thank you, Polly. They were some really brilliant practical tips, and I think on the enforceability, getting deadlines within the month is particularly effective, and it's useful to think of what the realistic goal of the mediation can be. And I think what you said was very helpful about trying to agree the interim position or perhaps some parts of section B. So there's a lot of food for thought there. Thank you very much. And quite a bit, I suspect, for Margaret and Kate to pick up on, who are coming next with the mediator's perspective. And I know you'll have your own comments, but it is interesting what Polly has raised about the role of the mediator, both with enforcement and in particular for unrepresented families. But you may not have time to deal with that. But over to you both now.
Thank you. That was really interesting, Polly, really helpful. I mean, I like the 10 tips, all of them, very much. And I don't know, Kate, how you want to do this, but I know we wanted to talk about a couple of cases, but I just wanted to pick up on some of the things Polly mentioned. Do you want to do that first, or?
Yeah, you can start, and then I can follow up some other thoughts.
I completely agree with you, Polly, about the value of lawyers in mediation. And you know, originally, as you said, in the early days, you know, almost 20 years ago, there was a lot of skepticism about lawyers' role in mediation, and we had some funny language we used around, you know, kind of, it's not really the right setting for lawyers, that sort of thing. But actually, I think things have changed, and certainly, as you say, a lot more lawyers understand kind of what their role in mediation, you know, the value they can bring to a mediation in a way that I think maybe people still have some preconceptions that lawyers are going to bring all that adversarial sort of stuff with them. So I know from my experience, it's always been really helpful, and not always a lawyer, but I mean, you know, certainly somebody who's familiar with the legal framework, because this leads to your other point, because mediators can't obviously give advice, and so we really want somebody there who can give the parent or young person advice, because we don't want somebody to be compromising, compromising their rights or reaching agreements that aren't safe. And I think you raised a really good point about what the mediator's role is in that. But certainly on the timescale one, that is something we would all have to do, is be sure that any actions that are in there are the outcome of those actions will be known before the tribunal, the deadline for putting in an appeal. So that would be part of our responsibility in terms of writing all of those and checking the timescales are not putting somebody's right to appeal at risk. But some of the other things I think are really much more difficult. And Kate and I were earlier talking about some of the difficulties you have as a mediator about raising the legal points. You know, we have the option to have separate meetings within the mediation, and so sometimes that's a useful place just to flag up some questions about the local authority's position, or to check the parents' understanding of any wording they might be agreeing to. And the point about quantification, specification, again, that's something that, you know, we need to know that that's really essential in the plan. But, you know, I don't know how much that's happening in terms of mediation. Sounds like from your experience, it's not always happening in the way that it should. I don't know, Kate, do you want to add anything to this?
No, I share that. I think it is part of the mediator's role to ensure that it is any agreements being reached are enforceable both within any amendments being made to the EWHC plan or any other agreements being made. There's a way forward. I was actually going to pick up on the point, one of the points Polly started with about getting everybody round the table. That's what I totally agree. That was my top tip, that mediation, it's so easy to get into a situation where people are in fixed positions and it's an adversarial process, and you're criticizing past actions and failures in the decision. And mediation's a chance to get the right people round the table, solution focused, looking forward. And quite often, I think, as Margaret alluded to, those decisions around whether a needs assessment is actually needed, those decisions sometimes are based on paperwork that is perhaps just not well enough put together by the school, or it's not communicated effectively. And having everybody in the room and being able to ensure that the decision maker has the right information that they need to make that decision can be an incredibly powerful tool. You talked about the fact that we've been using virtual mediations because of the pandemic, how that will continue. One of the things that's been an unexpected positive is that, as Margaret mentioned, is that sometimes children and young people have been more able to be involved in the process, and whether planned for or otherwise. I mean, I've had a mediation where the child that we were having the mediation about came on screen because it was the mediation was, the mother was in her own home and he wanted to ask her a question, and it was so powerful. It was so powerful in making it very difficult for anybody to ignore the needs that he had. And when it's on paper, that can be a very different exercise for when it's been brought to life, either in the process of the mediation or actually meeting that child or young person. And I also think it's a really human conversation. A decision making a decision on paper is very different from when you're meeting the people involved and the lives affected, whether it's the parents or the young people and children themselves. And it's an opportunity to look for different solutions beyond the formal rigid process of the EWHC legal process. And as you say, Polly, it's quicker. So many of the points that you've highlighted, I'd echo and say are the advantages for families. I cannot more strongly agree with your point about the value of either having a lawyer or someone with a good understanding of the SEND framework in the room. It can be very frustrating as a mediator when a position is being held by one side or the other, but it's not consistent with the SEND framework. And so you can only probe and challenge as a mediator so much. You can't give advice, and so often that can be helpful. But I'm interested that in the chat, somebody's asked about SEN advocates and consultants who are not regulated. It is true that I have had experience where it has been difficult to assess whether the advice being given to the parent is in their best interests, and that the presence of that person hasn't always been totally facilitative. But you can, as a mediator, use the opportunity to have more confidential discussions, as we call a breakout, or you can just about manage it in a virtual platform, having a private discussion and asking very what we call sort of reality checking the advice or questions being asked. So you can try to probe it, but that can be it can very exceptionally be a challenge. My vast experience is that SENDIAS provide a real valuable input, and often they have local knowledge, so they can add additional information that may not be available to the parent. And actually, as I've noticed in the chat, Susanna from Kids has mentioned that too, but also she's mentioned that going forward there's likely to be an option from Kids, and I imagine other mediation services, that you can choose whether to meet face to face or in a virtual mediation, and particularly where you've got a lot of different professionals who may be in different parts of the country, or in different parts of London. I think that virtual mediation can be a really positive option. I also wanted to mention that the mediation process, we talk about legal processes as being adversarial. One of the aspects of mediation is that there can be a triangulation. You've got the local authority, you've got the school or the placement, and then you've got the parent. And sometimes it can be a dispute or a disagreement between the local authority and the school, in as much as the parent can be stuck in the middle. And it's great to use mediation to get everybody in the room to unpick that. And that's not something necessarily that's so easily done in an adversarial process. But those are the points that I wanted to add. I also noticed that there was a question in the chat, and I don't know if it's okay to pick it up now, from Elizabeth Stanley about the high settlement rate. But I think we have explained that doesn't mean that of those agreements they don't go on to appeal. What's also interesting to me as a mediator is I don't tend to find out if the agreements I've been part of facilitating break down. And so I go off hoping that they are going to be adhered to and followed. Certainly the information that's given out by the government is that their understanding is those agreements are usually adhered to. So it's interesting to receive some feedback that they're not always implemented in practice. So those are my thoughts. I'll hand over to Margaret.
Just on that point, Kate, I think it's important that when we talk about that figure that the government gives of 88%, we really shouldn't be talking about settlements, because as Polly said, it's often about agreements that are reached, but some issues, sometimes the key issues, sometimes an issue where it's just clear that's not going to be agreed. So if you look at the figures from say Kids' rate of agreements in SEND mediation is 88%, but the DFE reports that 27% of SEND mediations go on to appeal. So obviously there's an overlap there. So we're not talking about settlement versus non-settlement, we're talking about agreements reached. I guess what people want to know is the sort of thing Polly's talking about and you're talking about in terms of, what things can come out of it, even if it's not kind of settled in that sense and fully resolved. So in a way, I think we should just move away from talking about settlement and talk about agreements reached and outcomes that are reached, because as you say, there are so many other types of outcomes. I'm just thinking of some examples where like you mentioned, schools and colleges can be there. Often schools and colleges are really in an uncomfortable hot seat in mediation, and they're being told you need to make this provision. we don't need a plan in place for that. I mean, I can tell that I think increasingly schools are being a huge amount of pressure being put on them. But on the other hand, when you do have schools and colleges there, you can talk about what the support will really look like. And if you've got the young person there, you can talk about what works for them, what doesn't work for them. So you can really get into the nitty-gritty of that. And also sometimes if, for instance, if it's a needs assessment and there is agreement to reach this, to carry out the needs assessment, parents might have a lot of questions about the process, what their role is in that, which experts are going to be, where advice is going to be sought, and who their primary contact is going to be, because that's the first time they'll have a named caseworker in the SEND team. So that kind of communication stuff that starts to build this relationship, it's going to be a long relationship. We can have those conversations there in mediation. And I think, some of the things that I talked about earlier about the building up the skills of conflict resolution. I mean, most of the people I know who came into mediation came into it because we saw it as a way to kind of help people build their own conflict resolution skills. Not that we need to come in and be the savior in our cape and resolve other people's problems, but really to help them to develop the skills. And so sitting around the table, as you say, Kate, it's like modeling that kind of collaborative, supported decision-making, working together. And I just wanted to talk about one case that I thought was really, really lovely. And I know we've been talking about how things are going to go forward in terms of remote mediation moving forward. I'm very concerned about what we're calling a hybrid model, because like Polly, I really prefer in-person mediation, much prefer it. But I also see the advantages we've had from online. But what I wouldn't want is a situation where we've got some people online and some people together in the room, because I think we're going to have a dynamic there potentially that's going to be really problematic. So we may be heading toward that, but I just think we need to think about the design of what we want going forward. And one of the things that's lost in the online mediation is people conferring with their legal rep or their advisor or their advocate, because they can only do so remotely in a breakout room usually, or on a WhatsApp chat or something. So it's not ideal in that way. But I just want to tell you about this one case, which was a remote one, and it was a young man on his, representing himself. He didn't have there wasn't a parent involved in that. And he was a 20-year-old with autism, and he'd been diagnosed with paranoid schizophrenia. And he was supported by a mental health worker with specialized in young adults with mental health issues, and someone from Connections. And he hadn't, the information, obviously, it's as you say, Kate, the information that went to panel was so incomplete and did not give the full picture. And it said that the setting can provide the support that he needed. He hadn't been in a setting for 2 years. And there was so much that was able to come out in the mediation in terms of his aspirations for returning to college, what sort of support he would need. And he was really able to describe that. And his advocate was just in there with supported decision making. She absolutely empowered him to say what he needed to say and to be involved in the decision making. And one of the really sweet things was that he didn't want to be on camera for the whole thing. He just didn't want to be on camera, which is fine. I mean, if that's somebody's preference. But at one point he was talking about how much he loved his dog. And I asked if he could turn on his camera so we could see his dog. And we got to see him and his dog, because he happened to be in camera in the picture as well. And for the local authority, that was the first time they'd actually seen him, because this was a request for assessment. So he wasn't known to them. And it was just, as you say, Kay, it was quite powerful in a way because it brings the people in it in a really human focused way that I think the paper decision making just never can do. So I think that's kind of what all I wanted to say. I don't know if we want to have more of a discussion of some of Polly's points that you raised about the top tips.
Yes, I mean, I was just remembering as you were recounting that story that although sometimes mediation can be frustrating, because when faced with a fuller explanation of a child's needs, if it's a needs assessment situation, the local authority almost immediately within the mediation makes the decision that they can undertake the needs assessment, and you think, why did we have to all come here? But just and that can be frustrating to feel that's put the parent and family through a lot of stress, and preparing for the mediation. It's a big deal. but sometimes there can be real positives in bringing people together. And I'm really conscious that quite often this is the first time that people are meeting face to face, and that as has been mentioned by James in the chat, it's an ongoing relationship with the local authority. And that just meeting face to face, I quite often feel like at the end of the mediation process, even if it hasn't reached the resolution the family were looking for, I often feel that the local authority representative really is on the side of the family, and they are championing their cause, and they do want to move forward to ensure that child's needs are being met, even if they don't, for example, think the threshold for an EHCP has been met. So I think there is a real value in bringing people together. So Polly's first point was, why not? And there are limited, I think, disadvantages to mediation, although I know that some people do find it a very frustrating process when the local authority don't change their mind about something that has got such a huge amount of influence over the family's lives. So I do think that it is something, I mean, what I would encourage is we always offer the opportunity to speak to families and other participants before the mediation. Make use of that opportunity, because it's an opportunity to really get clear in your mind what you want to bring to the mediation and what you want to discuss. So particularly with virtual mediation, taking that opportunity is one that I would encourage you to do. And keeping those relationships intact, particularly where a child is in a school is otherwise working for them. You really want to feel that everybody can work together and have that continue, because that continuity can be really important to the child. So those just a couple of other observations.
Thank you. That's all really interesting. I mean, a couple of things jumped out at me from the various presentations, and I don't know if anybody wanted to say anything more, but Margaret, you touched on confidentiality in particular and how that could be problematic in certain, particularly in a public law context, as in the SEND Tribunal. And I don't know if you wanted to say anything more about that, or Polly, from the perspective of families, if that's something which is difficult to understand or can be problematic if there's a subsequent appeal following from a mediation, or whether it's not much of an issue in practice.
I think it has benefits and it has disadvantages. I think the benefit is that you can have a full and frank discussion during mediation, and to really think about I've had conversations in mediation where we'll say, look, we're prepared to accept fortnightly direct therapy if you agree this in mediation today, but if you push us to tribunal, our experts say weekly and we're going for weekly. You would never have those conversations outside of a without prejudice safe discussion. You can be quite creative in terms of finding solutions. If you agree this, we won't pursue this. And I mean, obviously all the time you can't lose sight of what's in the child or young person's best interests, but recognising that the outcome at tribunal is never guaranteed. I think that part of it is a good thing. But one thing to be thinking about, though, is the status of the mediation agreement at the end, and whether that is confidential, or whether there is permission to share that. And I think having clarity around that is really important, and because sometimes you need to be able to give that mediation agreement to third parties, and so thinking about exactly who you might need to share that document with at a later date, so that can still go to the people it needs to. That's probably.
I think on the outcome form, I mean, certainly what I always say is that the outcome is not confidential. It doesn't mean you can send it to the Daily Mail, but what's understood by that is that if you need to show it to the tribunal, if you need to show it to colleagues in the local authority, if other people in the school setting need to see it, that's okay. And so what's written on there is written in the knowledge that it's going to be seen by other people. And I think that is really important. And to some extent, that gives me sort of reassurance about proper sort of scrutiny of what's coming out of mediation. But I think with the discussion, I totally agree with you, Polly. Sometimes there are times when it's clear that the confidentiality of the discussion means that people have been freed up to propose things they might not otherwise, and that they don't want passed on outside the room. Or sometimes on local authorities' part, they can be very honest about some things that they wouldn't say otherwise, and it helps I think it helps build that trust. Ironically, they might be honest about some rubbish thing within the local authority, but it can help build some trust as well. But I think what I find out on a practical level is that often there are people outside the room who need to implement some of these things, and they need to know some of the things that have been said. So sometimes the way I get around it is I say, it's up to you whether this is confidential, and if you all agree at the end that it can be shared on an as needed basis, then I can write that in the agreement form. But it would only happen, in a situation where it seemed that information might need to be shared, and I don't want it to be a barrier or a constraint on people to make progress and move things along for that child. It's a bit of a fudge, but I do think it's an interesting issue to explore, that concept of confidentiality.
Yeah,
Kate, if you've got views on that.
Well, I guess it was sorry, just sort of the issue arising from the issue of the process being confidential and not open to scrutiny, is that, as ever, with so many things happening in children and young people's lives, there's not enough understanding and research in terms of, for example, why there has been such an exponential rise in the number of SEND mediations and, of course, tribunal claims. And so there feels like there is a need to have some oversight of the process and look at why, for example, there's such a high number of mediations relating to the needs assessment, because it may show some patterns. I think there is available data about the decisions being made on a local authority basis. So you could see that maybe some local authorities are more likely to allow needs assessments, and others may be putting in a higher threshold, because I think that you don't want the mediation process to be screening or masking poor decision making. So I do think there does need to be some oversight, but it may be that can be achieved by looking and monitoring the statistics and the decisions being made. But you'd want there to be some shared practice and some positive good practice being shared between local authorities in terms of wanting to make sure that children's needs are being met in the most appropriate way.
Thank you all for that. And I think we've probably dealt with most of the comments in the chat. I mean, one question I had, and it's been touched on just from your perspective, are there some types of cases which are more suitable for mediation than others? Obviously, it will presumably depend on the facts and how entrenched perhaps the parties' positions are. And I very much hear everyone saying there's often not much to lose from trying. But are there types of cases that what are the types of cases that when you see, you think this is perhaps not going to be as fruitful as other cases?
I can step in and answer that, but I know that Polly had to let us know that she'd be leaving a few minutes early. So I just like to take the opportunity to just check that she didn't want to respond to that.
No, it'll be really interesting actually before I go to hear your answer as a mediator, which ones you see just never settle or do.
I mean, my answer is going to be a frustrating one, which is that you look at the papers, you look at the way the SEND mediation service that I work with invites both parties to write an agree to mediate form and setting out the issues they're bringing to mediation. And sometimes you think they're never going to meet. There is absolutely no way they're going to find a way forward. And then the unexpected happens and quite the reverse. So I don't think that there are ever situations when the cases are totally unsuitable from a mediator's perspective, because I always believe that there is something to be gained, even if it is just narrowing the issues. I think if I was going to put my lawyer hat on, I think if there is clearly a disagreement in terms of the interpretation of the law, and you don't have lawyers in the room who are able to engage in that legal discussion, I think that's an area, certainly as a mediator, that I've found very difficult, because I can't express an opinion, and I can't give advice, but there doesn't look like that they can resolve it, because if an interpretation has been drawn by a family and interpretation. Polly's leaving us, so thank you so much, Polly. Then it's very hard for you as a mediator to facilitate a way through that, because they're reliant on legal advice, and there's not a legal advisor in the room. So that's one observation of the sort of disputes that are very difficult to resolve in mediation.
I think just to add to that, I think Section I disputes that are purely about Section I, and particularly about residential placements, can be really difficult in mediation, not impossible. And it doesn't mean that it's not worth having the discussion, but often local authorities need to be directed by the tribunal to name certain placements. And I think the issue of refusal to assess, I said earlier, I don't even think they need to come to mediation, although as Kate says, you know, it's often really helpful because you get people around the table. But those are likely to get agreed in mediation, but also interestingly, they're the most likely to be conceded tribunal as well. They tend to fall away before they go to tribunal decision. So yeah, like Kate, I don't think I have any sort of hard and fast rules about never go to mediation with this issue.
Thank you both, and we are coming to the end, but there's a couple of comments in the box, and Helen, thank you for circulating some information about confidentiality more generally, which might interest people. But Alice has an interesting question, which I would also be interested in the answer to. So do you have any experience in running mediation after an appeal has been lodged to try to narrow the issues? And presumably that's outside the funding position. But have your services, are they often engaged at that subsequent point, and is there a benefit in that?
I think generally they are not engaged because they are working within the framework that I set out, so they're being funded by the local authority. But there's absolutely no reason why it shouldn't be explored. And if you have managed to get legal aid funding under exceptional case funding, then that should definitely include funding mediation. And if you're being privately paid, again, it can be quicker than waiting for the tribunal. It could narrow the issues. So you could either go to a SEND mediation service, you could come to Carden Court Mediation, and just instruct a mediator directly that way. So I think it's probably underutilised. Unfortunately, mediation is underutilised throughout the civil justice system, and one of the great positives about mediation being placed in this statutory footing within SEND mediation is that it does seem to mean that there's a greater uptake of mediation, and there's just an expectation that it will be considered, because there's very limited barriers for families to access it. So I would like to see greater opportunity to mediate once cases have reached the first tier type tribunal. I feel like that has been explored. Margaret, do you?
I don't know much about it in the context of the SEND Tribunal. Whether, I mean, I don't think I've done any or many that have come to us after the tribunal has made a decision. And in the context of judicial review, I know when we did that work with Public Law Project, one of the things we found was it can be helpful at all stages, you know, pre-action, but also after permission's granted and after a judicial review in terms of, say, a point of law or something. So I agree with you, Kate. I don't see any reason why it wouldn't be. I think the problem would be the incentive for the local authority to mediate at that stage. It might not be there in the same way that it is before the appeal's been lodged.
But on the other hand, it's incredibly costly for the local authority, and both in terms of the cost of the legal fees, but also in terms of their time to go to tribunal, and I think quite stressful. But
we're talking about after a tribunal has made a decision. You're talking about, or after it's been lodged. I think
once it's been lodged.
Once it's been lodged, yeah, absolutely. Sorry, I misunderstood. I thought you were talking about following a decision by the tribunal.
No, once it's been lodged, I think that should really still be an option. And actually, you could approach the local authority and ask whether they would fund it through their SEND mediation provision. But you may, but you may also be able to approach another mediation provider.
Yeah, I mean, we certainly do mediations where it's been lodged already, just to secure the parents or young person's right to appeal, and then the local authority has agreed to mediate it, although it's already been lodged. That's absolutely.
I think that could be really useful. I mean, I've certainly proposed early kind of roundtable meetings and things, but the role of a mediator after the appeal has been lodged and when the evidence all prepared, I think is a really useful suggestion. So thank you for that, Alice. I think our time is coming to an end, but I just have to echo what Polly has said and what hopefully all of our participants feel as well. It's been a really interesting conversation, which I know we could have gone on for much longer. And it's interesting just to reflect on the growth of mediation in SEND, which of course is likely to have parallels in other areas, and to consider the issues of principle and practice that we have. I found it really beneficial, and I just want to extend my very sincere thanks to you, Kate, and to Margaret, and of course to Polly, who's had to leave. Thanks also to Ollie, who's on our line and has helped with the presentation, and to all of you for coming along, for your interesting comments and questions, most of which I think we dealt with, although there were a couple coming in at the end, and we might have to have a follow-up session, such has been the interest in this. But thank you all very, very much. The material will be circulated, and thank you for joining us, and have a lovely evening.
Thank you.
Thank you, Grania. Thank you.